So today's presentation will be primarily on Hawaii's landlord tenant laws, focusing mostly on the statutes that support these laws, as well as some housing discrimination issues, some general kind of graphics that I wanted to share and examples in real time of various letters and forms and documents that you might see while you're out in the community, as well as a bit of information on, some public housing regulations. A lot of these laws apply equally to both private units as well as, many of the state's public housing units. So starting first and foremost with the landlord tenant code, it's codified under the Hawaii Revised Statutes, Chapter 521. If you were to look at this, it would be, very wordy, and some of the sections are very straightforward. Others are very complex with many subsections. But the DCCA has a great resource called the Landlord Tenant Handbook, and it's basically a summary of these laws broken down into individual sections. It's available to the public. It's on PDF format. You can print it and review it, show it to clients, folks in the community. It's a really good resource, in my opinion. And that's available at the link provided here. If you just search DCCA, which is Department of Consumer Affairs, Landlord Tenant Handbook, you'll be able to find it. And as I said before, these rules and regulations apply to both public and private housing units in the state. So the different types of leases, you might think that, all leases are written. If you've worked with clients at KPT, at Michael's, they're really good about always having a written lease agreement. But under the statute, it's possible to have either a written or an oral lease agreement. So if the lease agreement is written, basically all of the material terms, all of the major terms should be specified in that document. The length of time, who the landlord is, who the owners are, who the occupants are, adults, children, what the rental amount will be, what the length of the term will be, and what the late fee, cost might be, as well as normally you'll find house rules and other sorts of regulations and provisions that pertain to that specific unit. So it's possible, usually what we see is a lease agreement that's for 1 year, and then after that year expires, they'll either sign another year-long lease agreement, or it might automatically become a month-to-month lease. However, if an individual has an oral lease, which you don't see a lot of, I've seen a few over the years, heard of a few rather, those by default are considered month-to-month, just on an ongoing basis. And as I said before, both of these forms are allowable, although for reasons that you can probably imagine, the written form is much more advisable, especially when you get to a point where there's a conflict or a disagreement, because both parties can then point back to that original lease. And the leases that I've seen from Michael's and other private units are generally drafted on like a template or boilerplate form. So this is an example of a boilerplate lease agreement. This is something that's created by the Hawaii Association of Realtors. And as you can tell, it states all the major sections that I mentioned: the date, who the tenants are, where the property is located, what the rent is, what the late fees are, the security deposit, the rental term, so on and so forth. And what you'll find is behind that document, you'll have a series of house rules, other addendums. If there's lead paint in the property, then by law, that also has to be disclosed as well. And if it's a public housing property, you'll also see probably a bit of records and documents as well that pertain to the various public housing laws and regulations. So we've talked about how a lease is created. Let's talk about how a lease ends or how it's terminated. Regardless of how the lease came into fruition, whether it's a written lease or an oral lease, whether it's done on a boilerplate form or someone just handwrites a contract, the lease termination must be in writing. And if an individual is on a month-to-month lease, the landlord or the owner or their attorney, they have to provide 45 days advance notice in order to effectively terminate that lease. We were seeing a lot of leases and terminations during COVID where folks were getting the computations wrong. They weren't giving written notice. That's all inappropriate. The law is very clear what you need to do in that circumstance. It's possible that a tenant might want to terminate, and there's certain circumstances that would allow them to terminate early and without any sort of penalty in the situation of domestic violence or court order, or say they have to vacate if they're in the military, something to that degree. Generally speaking, if they're on a month-to-month lease, and if they as a tenant want to terminate the lease early, they need to provide 28 days advance written notice. But the one thing that I want, everyone to keep in mind is that a lease termination is not the same as an eviction, right? So a lot of times we'll have clients, folks that'll come to us saying, help, I've been evicted. Okay, as a starting point, let's review your documents. What did you receive? We received the document and it's just a 45-day notice. So that is not the same as a court order that legally and lawfully allows for the landlord to evict the person. That's just what you see at the very beginning, start of what could be a bigger process. So that's something to always keep in mind, and I'll show some examples a little later in the presentation. However, keep in mind, a landlord is entitled to terminate a lease. We live in a no cause, no fault state. So the landlord doesn't need to be specific. They can just say, okay, if you're on a month-to-month lease, we're providing you written notice that we're going to terminate. This is, the end of the 45 days, whatever that date is. And at that time, we need the keys. We need to conduct an inspection, so on and so forth. The tenant can overstay beyond that date. If they do, they now become what's considered a holdover tenant. So essentially everything doubles on a prorated basis. If the lease was $1,000 for the amount of rent, after that expiration of the 45 days, the lease now, or the rental amount rather, now becomes $2,000 on a prorated basis. And if the landlord chooses to evict, then the tenant, if they do not prevail at court, they're also responsible not only for any unpaid rent that's calculated as a holdover tenant, but they're also responsible for attorney's fees and costs. And my experience, during COVID, working with these various rental assistance programs, as I'm sure you folks know, you guys are the experts too in this area. They'll pay for unpaid rent. They'll pay for some late fees, things of that sort. They'll pay for utilities. They'll never pay for legal fees. So we don't charge fees for our services, but landlords usually always do. And if the property is a corporation or an LCC, anything of that sense, then by law, they have to get an attorney to process their eviction. So you can anticipate that several hundred, if not thousands of dollars could be added on to the tab in addition to whatever the landlord is claiming that they owe. So it's best that, for multiple reasons, these things don't proceed to court. Looking at some of the obligations from a landlord's perspective, they have to provide a safe, fit and habitable premises. It can't be unsanitary and in a state of disrepair. That's really not technically allowable, although, as I'm sure you folks have seen, landlords, especially some private ones, they do not abide by this requirement. The landlord has to be safe, the property has to be safe. The landlord has to be responsive, and they need to perform necessary repairs that are not considered ordinary wear and tear. So if a pipe faults and it's in the wall, the landlord has to repair that. The tenant has to notify him and her of that. If the roof starts to cave in and it starts to leak, the landlord has to respond to that and repair that in a reasonable time frame. They also have to maintain plumbing, electric, and other facilities in good working order. Things like the toilets, they have to be functioning for health and welfare purposes. And the law also requires safe running water. I've heard of landlords turning off the water, turning off the hot water, messing with the electricity in an effort to kind of exert pressure on a tenant. You definitely cannot do that. That's not allowable under any circumstance, or unless you have a court order. I've never seen a court sign off on that sort of thing. Unfortunately, it does happen. The landlord also must furnish and provide the unit at the date and condition that's specified in the lease. So if the lease says the property is available June 1st, you have to provide the property on June 1st. And the landlord can't interfere with the tenant's use of what's called quiet enjoyment. So as a tenant, the tenants in the household have a right to enjoy the property, peacefully, quietly, in a, safe, serene manner. The landlord is not entitled to just kind of parade through the property at any point. Although I'll explain in another slide when the landlord is lawfully allowed to enter the property with or without the tenant's permission. So the other side of the coin, tenant obligations, they have to keep the unit in a fit and clean condition. They have to comply with all rules, laws, house rules alike. They have to supply payment in a timely manner. That's one of the biggest problems that I've seen with folks over the years, and for understandable reasons. A lot of the problems, a lot of the cases that I get that we've seen tend to be due to non-payment of rent, which is always, easier said than done, especially during the pandemic. Tenant has to allow the landlord an opportunity to enter the unit. So if it's an emergency situation, if a pipe burst in the property, the tenants aren't home, technically the landlord has to make a reasonable attempt to notify them, but the landlord or their agent is entitled to enter the unit in an emergency or under exigent circumstances. Otherwise, they have to provide 48 days advance notice, usually in writing, to inform the tenant and their family that they'll be entering the unit to do an inspection, to make a repair, that sort of thing. However, given that the landlord doesn't have free reign to the inside of the property, the tenant also has to report in a organized manner any issue that they're seeing with the property. So just as the landlord has a duty of repair, the tenant has the duty to inform. And I always encourage folks, it's fine to have a verbal conversation, but be sure that you're backing that up with some sort of writing, even if it's your own record. Send an email, send a text message, something that you can point back to if the landlord is saying, hey, I never got, any word that you had a problem. You have some form of evidence that says otherwise. So moving on to eviction. So this is where we're talking about a scenario where the 45-day notice has been sent. Maybe the landlord has sent a 5 or 10-day notice where they're demanding payment. And if the person doesn't pay, it'll result in a court filing. This is your traditional court situation when you're going in before a judge, you've been served with a lawsuit, and now, it's the real deal. So as I mentioned, Hawaii is a no-cause eviction state. The landlord does not have to provide for exact specifics about why they're terminating a lease. More often than not, if it's due to non-payment of rent, they will identify what months are deficient and what amounts are owed. But it's possible that the landlord can file an eviction due to things that have, no relationship to money. So if there's criminal activity or, some sort of a nuisance or rule violation that's stated in the lease as being a prohibited form of conduct, the landlord can terminate the lease and file an eviction for that as well. Typically speaking, the way it works is party gets sued, they get served, a court date gets set, people appear. Recently, the judges have been ordering people to mediation to see if they can resolve the problem. If they do resolve it, then the case is basically over with. If not, then it goes back before the judge. And as some of you have seen, because we've worked on cases together, you're just working on a series of ongoing court dates until essentially the case is resolved, or in most of these cases, until the payments are made. Folks don't have to, on the defendant side as a tenant, you don't have to be represented by an attorney, but it probably is advisable. I've seen some of these cases go up, several thousands of dollars, some 10,000+. At minimum, we always tell folks, if you're not able to get an attorney or contact us or have someone in your corner, make sure you appear for that first date. Because if you don't, the court will enter what's called a default judgment, which is basically the other side automatically wins. So you don't have an opportunity to present evidence. You don't have an opportunity to contest what is said in the document, any number that's in that document in terms of, payments that you allegedly owe. Because the tenant missed that date, the court has now ruled that that person owes that amount, and more often than not, that they also have to vacate from the property, which of course is not good. However, that rarely happens. I know you folks are great at catching these things early and, raising the red flag or bringing it to our attention. Only had a few cases where folks have slipped, between the cracks and have only sought help from anyone after everything is said and done. Hold on one second. Let me try to admit this person. But for the most part, practically speaking, in a lot of these non-payment money related cases, they're usually resolved through some form of a settlement agreement or rental assistance. It's just with some of the other cases where the landlord is saying that it's conduct based and the tenant is disagreeing, those, tend to drag on, and more often than not, the only way that you can resolve that other than mediation is maybe by going through trial. However, keep in mind the party that doesn't win, the non-prevailing party, has to pay for all the costs. So they end up having to pay for the opposing side's attorney's fees, which can be a lot. I wanted to touch briefly on the issue of discrimination because that is something that does come up, unfortunately, in housing. So the state has a separate law on housing discrimination, and essentially a landlord has a lot of discretion in what they can and can't do. There's a landlord tenant code, but under no circumstances can they discriminate against someone on the basis of any of these classifications. So they can't discriminate on someone on the basis of race, national origin, religion, color, sex, gender identity, and expression. They can't retaliate HIV status, age, marital and familial status, sexual orientation, and disability. If a person is on the receiving end of that, then the recourse would be to file a discrimination complaint, either with the Hawaii Civil Rights Commission or the Office of Fair Housing, or HUD, on the federal level. And we've done that before for some folks in the past. And it can be helpful depending on the situation at hand or what the problem is. And just kind of going over a little bit more specific on the Civil Rights Commission. So they have what's called exclusive jurisdiction, meaning before you go to court, you have to file first with the HCRC. So they handle not only housing and property discrimination, they also handle public accommodations cases, as well as employment discrimination cases. And as I said, the law in the state requires that the parties file at the agency level, either with the HCRC, their state agency, or with the federal agency before filing in court. Keep in mind, though, that if someone is raising an issue of housing discrimination, they have to report that within 180 days from the last date of the alleged act of discrimination. So it's essentially they have to file within 6 months. They can't wait 2 years or 4 years. Contract cases allow for up to 6 years, but these discrimination cases are very time specific. And in order to initiate the case, the party has to file what's called a pre-complaint questionnaire. And it's kind of just what gets the ball rolling. And if the HCRC deems that, there's enough grounds to file a complaint, they will then compile all the information in this PCQ, generate a complaint, and then serve it on the other parties. And then that's when the discrimination case gets going. But that's separate from, what we usually see by way of an eviction or some sort of lease termination issue. But I did want to bring this to your attention. And on the same point, I wanted to also briefly discuss reasonable accommodations, because I would say that this is an area where we've seen a lot of work, at KKV, and I know my colleague Ashley has started to see some of these issues also pop up at KMC. And this is a form of housing discrimination or disability-based discrimination. So for those that don't know or who aren't familiar, reasonable accommodations are allowed on the basis of disability to a tenant to allow him or her the ability to meaningfully enjoy a housing premises. So this could be installing a ramp, transferring a unit from a location that doesn't provide easy access to maybe one on the ground floor, but it could also allow for an accommodation or a waiver of a certain rule or policy that might provide some form of an impediment to someone with a disability. So the way it works is there's no specific way to invoke this request, although like everything else, we encourage that it be done in writing. The landlord cannot automatically deny the request. That, in many ways can be seen as a form of discrimination. The landlord has to enter some sort of good faith conversation with the tenant, their advocate, or the attorney to see if they can meet the specified need. They're also not a doctor, so the landlord or their agent, or if they have an attorney, they can't demand that, the tenant and his or her medical provider disclose all of these health records. That wouldn't be appropriate. They're only allowed to review what is needed in order to accommodate the request. And in a circumstance where maybe the medical condition is what's called latent, where it's not apparent, obviously, if someone has a prosthetic leg, it's obvious that they have a mobility impairment or disability. But if it's maybe a mental health condition or something internal, the landlord or agent might need something from the medical provider to confirm that this condition exists. And in that circumstance, they may be entitled, to receive those records. Keep in mind, though, not every case is the same. So what might be considered reasonable in one situation based on the resources of the landlord might be considered unreasonable in another situation. So think of Michael's. They're a big, corporate landlord. They have a lot of resources, a lot of money. It might not be hard for them to install an AC. Compare that to an elderly, landlord owner who's still paying a mortgage on a fixed income, who's renting out a room. It may not be feasible for them to allocate X amount of dollars to meet the same needs. So everything is kind of seen on a case-by-case basis. But in conclusion, I'm always a big advocate of making the request, put it in writing, get your supporting documents from your medical providers, and disclose, what's needed. You don't have to disclose your whole health record. A lot of the providers at KKV are really great about tailoring the letter so that it's not, revealing an unnecessary amount of information. And we're always available to consult with clients and their providers if they need further assistance with this. And this is just a lot of language, but it's basically the state statute on housing discrimination as it relates to reasonable accommodations. So you can always review this later, but generally speaking, just keep in mind, every landlord has an obligation to accommodate people if they have disabilities. I'll go over security deposits briefly. They're usually paid and agreed upon before the date of move-in. They should be listed in that lease agreement. By law, they're not supposed to exceed 1 month of rent, although I've seen times where it's beyond that. The landlord should also be performing a pre-inspection and a post-inspection, because in order to retain the security deposit, they need to show and prove that the condition of the property at the time of the move out was substantially different from how the property existed at the date of move-in. And if they intend to keep the security deposit, they have to provide written notice within 14 days of the date of departure. Otherwise, the tenant is entitled to have the entirety of their security deposit returned to them. It can also be used to cover related costs other than reasonable wear and tear. So if there's damage to the unit, things need to be replaced. The law specifies kind of what is allowable. And I've included a link at the bottom here from the state court's website, which goes into further detail. One thing, unfortunately, to keep in mind is that being that these cases go to small claims court rather than district court or circuit court, like an eviction case or a housing discrimination case, the law does not allow attorneys to represent tenants in these actions. And I think the thinking is because sometimes the attorney's fees and costs might cumulatively on both sides be more than the amount of the security deposit. So that's not to say that the tenant is without any form of recourse. What it would basically require is that we could help to counsel them and prepare them if they choose to file, a small claims action against their landlord who has wrongfully and illegally kept the security deposit. So we can always counsel folks, through these situations and explain the procedures to them and support them in whatever decision they want to make. I wanted to share a few documents before we conclude, kind of wrapping up here. This is a sample 45-day notice. So this is just a general form that either a tenant or a landlord could use to notify someone who's on a month-to-month lease that they intend to terminate the lease. So of course, this would all be filled out, and a landlord could provide this, a tenant could inform. If a tenant were to inform, they just need 28 days. In theory, any lease terminations coming from a landlord should be in writing, and you always want to make sure that the date that's being listed is the appropriate date. I've had landlords, usually private landlords, who don't know the law. They are attempting to send these lease termination letters, but they don't know the law. They can't calculate the time. So they end up sending letters that are 2-week notices or 1-month notices. And of course, that's not allowable. So then we just have to write them a letter saying that, your notice is defective. Please correct your notice. We're not going to give you advice on how to do that because we represent the tenant. So you need to read up on the law or get an attorney to do it for you. I've seen those things happen. Usually the bigger landlords, they have their letters, already on file. So they're usually pretty on point when it comes to things like providing advance notice of lease terminations. One other thing to keep in mind about 45 days is that that number also applies to rent increases. So if someone is on a month-to-month lease, I just looked at this before we logged on. The state law basically says that the landlord has to provide 45 days advance written notice if they intend to raise the rent. So that's always something to keep in mind because we've seen situations where, tenants' rents spike up and there doesn't seem to be any notice. Taking that on face value, maybe an argument would be, hey, you didn't provide the correct notice, so legally you can't raise the rent. It's always something to keep an eye on. This is a notice of default or a demand letter. So this is, after the 45-day notice has been generated. In the past, the landlords used to send 5-day notice letters. Now they tend to be 10 days. And basically, the gist of the letter is, give me my money in full by 10 days. Otherwise, we will actually terminate your lease and we'll sue you. So the letters become increasingly more threatening as things progress. And I've seen these letters also be attached as exhibits to the court filings so that the landlords and their attorneys can show, hey, we provided notice, we adhered to the law, we gave every opportunity, and the person was non-compliant or was not communicating with us, whatever it is that they're claiming the person is doing. But you can tell just based on the rhetoric of these letters, you can kind of get the sense of where, this conversation is headed. And then, of course, the grand finale is the actual court filing. So this is what an actual eviction document looks like. It's not a letter, it's not a notice, it's a lawsuit. So you'll see it on the top: complaint, assumpsit, summary possession, landlord tenant seeking damages. There's usually a declaration, which is the attorney, laying out their narrative, exhibits, and then the summons, which is the legal document that says you have to appear here at this date, otherwise we're going to rule against you. So everything should be included in this document. I always tell people, if you have someone knocking on your door with a document that looks like this, that asks you who you are and for you to sign, that should be a good indication that things are now, kind of ramping up and you need to really seek legal advice or some help. And you can also tell because this looks like something the court would issue. This is literally their form that they provide at district court. All lawsuits that are filed will have this here is actually in red. This is the filing stamp of the court. as well as the clerk stamp at the bottom. So if you see this or see someone with this, that should immediately raise a red flag. Give us a call. There should be a corresponding document in this packet that will also provide the date of when they need to appear. And the courts have been really good, even post-COVID, of allowing people to appear remotely. And even if the person doesn't have an interpreter or can't schedule one with you or us, or something's happening where it's very short notice, just go to court, make a denial, ask for an interpreter, because at minimum, the court will grant another date. You know, I've seen a few cases recently, maybe one where we didn't get the referral. I don't even think it was brought to your folks' attention until everything was done. And the client brought in what they thought was this complaint, but it was actually the document that legally allows the landlord to evict the person. On the bottom, it said, you know, changing of locks to take place on Wednesday. We had our first consultation on Monday. And miraculously, I was working with, on that case, it was May Lynn, and she was able to give some assurances to the landlord. We were able to refer the person to rental assistance, and, you know, as of right now, they still haven't executed the writ. They haven't enforced the eviction. So that's great. But, you know, ideally, we wouldn't want for the clients to be in that situation. So if you folks see and hear anything, feel free to let us know. And on the topic of evictions and writs and enforcing evictions, I wanted to share this recent article because this literally just came in over the weekend. So this is an article that was published on Hawaii News Now, and it basically is saying that the sheriffs, as far as I understand it, law enforcement, they're taking a temporary pause on enforcing these evictions. So I didn't share it as an example, but when a case is all said and done, and when the landlord gets the legal document which allows them to remove the person and their belongings from the premises, that's called a writ, W-R-I-T, a writ of possession. And then there's also what's called a judgment of possession. When that writ is issued, the court is done. You know, the judge's work is POW, the attorneys are POW. There's nothing more to do. All that the landlord needs to do to execute on that is call the sheriffs. It's usually the sheriff, sometimes it's HPD, and they will say, okay, I have this document, you can look at it. I have the legal right to remove this person. Can you help us do that? So as you can imagine, it can become dangerous and hostile. And what happened a couple of weeks ago, I don't think, thankfully, it was in the Kalihi area, it was somewhere on the west side. There was a long standoff. The sheriffs came down. The landlord had the legal and lawful writ, so they could actually remove the person, and it got dangerous. And there, I don't know if weapons were involved, if police were harmed or their canines, something happened. And because of that, they made this announcement that for the foreseeable immediate future, they're not going to execute on these writs, which is good to the extent that it gives people who are in that very dire situation a little bit more time. But it's not a complete solution, because they could make an announcement tomorrow saying, okay, we've reviewed our policies and we're going to start enforcing these things. Landlords, owners, give us a call. We can enforce, you know, your writ and have these people evicted. So I wanted to share that, you know, because it is relevant to the conversation. It's not a solution. I wouldn't hang my hat on this for too long. I wouldn't put any or all of my eggs in this basket. Your best, you know, option, and this really only applies if you know, your client, or if the tenant is someone who's fallen behind on rent. My experience is, even until the very end, landlords are always willing to try to work with some sort of a deal, because what they won't tell you is that it costs them time and money to evict someone, to keep the property vacant and open, because that means they're not receiving rents. So I know Michael's, you know, despite sometimes their negative reputation, you know, in my experience, in the cases that I've handled, they've been fairly cooperative, and their intention is not to evict people. They do want to keep people housed. But if, of course, in order, you know, for us to get involved, and same with you folks, people need to bring these cases and these issues and concerns to our attention. I just wanted to share that briefly, and I'll conclude with just some tips. And a lot of this is just straightforward, kind of obvious stuff, you know. we always want folks to read their lease, ask for an interpreter when it applies. So if they're in state or county public housing, they have the right to an interpreter. Not so much if they live in just a private situation, but I would still encourage people to read what they're agreeing to, because this is essentially a contract. You're making payments, ask for receipts, do your best to stay up on payments. Don't give landlords any reason to put you or your household under a microscope. So do your best to comply with all house rules. Sometimes landlords are very strict and they kind of develop a negative relationship with certain households for whatever reason. So they might be more strict than other times. But generally speaking, I tell people like, just abide by the rules, especially when it comes to things like bringing guests in and people that are staying in your property for extended periods of time without approval. You don't want to do that, too often or without providing notice, because in most leases, that could be a grounds to terminate your lease if it's done too many times. Anytime you're communicating with the owner, landlord, or property manager, put it in writing. I even do it for myself. I live at a townhome. Anytime I'm communicating with the resident manager, property manager, anyone in the board, it's just, I have a written record of that. For the next point, just to keep a record. And again, seek legal help when needed. So if folks are patients, clients of KKV, they have access to our services. If not, sometimes we're able to take a case if they live in the Kalihi area. At least traditionally, that's kind of been our approach. If they're on another side of the island or have no relationship to KKV, have never sought services there, then we most likely would refer them to legal aid or volunteer legal services, or they can also retain a private attorney as well. Here's my contact information here. We're back on site now on Thursdays from 1 to 4 p.m. at the Wellness Center in the health education rooms. I know I've been working with some folks, some advocates that have come by, and we've been talking about cases and doing meetings. That's been really great just to see everyone. Tuesdays, we work remotely from the afternoon, either from home or from our law school office. If you folks ever want to meet, we can arrange for a meeting there as well. We have a lot of meeting space there. And yeah, I'll just open it up for any questions.